I'm Leandra Letterman, and today's topic is legal research. I'm really pleased to have a guest speaker today who will lead us through a discussion of the research process.
I'm Ashley Ahlbrand, and I'm the Assistant Director for Public Services at the Jerome Hall Law Library at Indiana University Maurer School of Law.
Ashley, how do you usually recommend starting a research project?
Well, when I'm discussing legal research with my students, this path pictured here is what I typically recommend to ensure an efficient and effective legal research process. Depending on your level of expertise and familiarity with the topic that you're researching, you might vary from this path somewhat, but the steps depicted here are a helpful starting point for any legal research scenario. As rudimentary as it may sound, when you set out to research a legal topic, I recommend that you first start by planning your research itself. There are multiple reasons why this is important for a legal practitioner. First, time is money, so having a plan before you start researching will make the process more efficient. And in the context of online legal research using paid subscription services like Lexis and Westlaw, research is money as well. So you want to make sure that you know what searches you want to run and what sources you need to consult, rather than going in blind and just running random searches. So at this stage, then, what you want to think about are questions like, what legal issues can you identify? And are there any issues of fact that could influence the application of the law? Other things include, what is your likely jurisdiction? And considering each of those issues before you jump into research will set you on a more efficient path forward.
Those are great points. Answering legal questions typically depends on applying the law to the facts. So identifying the factual and legal issues is really important. After you've planned your research, you need to figure out where to start. Let's talk about primary and secondary sources.
Well, as you get started on research, it's often helpful to start with secondary sources, especially if you're dealing with an area of law with which you're less familiar. For those that are unfamiliar with legal research, because a lot of different disciplines talk about primary and secondary sources, in law, we divide legal research materials into two categories, again, primary and secondary sources. Primary sources in law are the law itself, such as statutes, cases, and regulations. Secondary sources really are anything else, anything that explains or analyzes the law or even critiques the law. The end game in legal research is to find what the law says, so to find those primary sources that are of relevance to your legal research question. So it can be tempting to go straight to cases or straight to statutes when you start your research. But secondary sources can be extremely helpful at the onset of your research process. If you're researching an area of law in particular that you're less familiar with, the explanation, background, and analysis that a secondary source provides, such as a legal treatise or a law journal article, can often help you set your research process off on the right path. But even if you're reasonably well-versed in that particular area of law, secondary sources are still an excellent place to start because the sources they reference in text or cite in their footnotes are most often the critical statutes and cases addressing that legal issue. So starting with a secondary source can often be a strong launching off point for your research into primary sources. So primary source research is the ultimate goal here. What does the law say in answer to your legal research question? As you get into primary source research, one thing you should always ask is whether there's a statute that addresses your question. If there is a statute on point, in almost all circumstances, it must be followed, and a court will be obliged to interpret the statute's meaning and apply it to the case at hand, unless the court finds that the statute is unconstitutional. But that doesn't happen very often. That said, for the general legal research process, as a common law jurisdiction, much of U.S. federal and state law comes from case decisions themselves. Tort law is often a good example. If you don't find a statute on point, don't panic. That could just mean that the issue that you're dealing with is a common law issue and there isn't a direct statute that applies. However, I do always like to caution my students that there's usually some kind of a statute you should find in the legal research process, such as statutes of limitations that would apply to, for instance, your tort law issue. But that does ultimately lead us to case law research. So even if you find a statute that directly applies to your legal research question, you will end up looking for case law to see how the courts have interpreted, applied, or criticized the law in similar cases over time. As your case law research progresses, you can use tools built into subscription databases like Lexis and Westlaw to find additional relevant authority. So remember to look at tools like the Headnotes to a case or the key numbers that you'll find right next to those Headnotes, as well as the citing references that a citator provides. All of these are different approaches that you can take to find additional relevant case law.
Ashley, you mentioned using a citator. Can you explain what that is and tell us a little bit more about it?
As you compile a list of legal authorities on your topic, both statutes and cases, it's important to ensure the authority you intend to rely on is still good law. The best way to accomplish this is by using a citator, such as Shepard's on Lexis, or on Westlaw, the citator is called KeyCite. And if you're on Bloomberg Law, they have a citator as well, and it's called BCite. A citator indicates the treatment of your source. And in particular here, again, what we're looking for is, most importantly, is there any negative treatment for the authority you want to rely on, such as if a court overruled an earlier case or found a statute unconstitutional. For statutes, citators will also flag pending changes to the legislation with a yellow cautionary symbol as well.
Ashley, as you've noted on screen, it's time to stop your research when you've gotten answers to all of your questions and the same sources keep recurring. Does that mean that this diagram is more of an iterative process rather than something you just follow one time through?
That's an excellent point. While I have presented here a visual of the process as a very linear format, it's anything but. When you get into the research, it's definitely more of a cyclical or iterative process where you may need to go back a few steps and come back through. In particular, as your research progresses and you start to uncover the potentially applicable law, there may be legal issues that come up in your research that you didn't think about at the beginning. So you may have to go back to your client and gather more critical facts, which may bring you back through some of those steps again.
This has been the research process.
Thank you for joining us as you break into tax.
Don't forget to like this video, share it with your friends, subscribe to the Break Into Tax YouTube channel, and turn on notifications so you don't miss any new videos.